Start. The only contentious cases the International Court of Justice (ICJ) can hear are cases between states. Individuals have no right of direct access. This is an important difference between the ICJ and other human rights institutions that allow some type of direct access. This limitation reflects the state centered view of international law prevailing when the statute of the ICJ's predecessor was drawn up after World War I. It does not mean that energetic and imaginative counsel can never get individuals' clients' situations before the court, as Donald Donovan's work shows. Still, it is a significant limitation. The ICJ also issues advisory opinions on legal questions if asked by the General Assembly or Security Council or by any another UN organ or specialized agency authorized by the General Assembly. The court has made some important contributions to human rights processes through advisory opinions, as I will mention later on. Para. There are no limits on the sorts of interstate legal disputes the court can hear. However, a few types of cases have provided much of its work. More than half its cases have involved disputes over land frontiers and maritime boundaries. South Africa generated four advisory opinions and two judgments. The court has also served as a sort of constitutional court for the United Nations. Several advisory opinions have established key principles regarding powers and functions within the UN. Para. There have been a few ICJ and PCIJ decisions significantly contributing to human rights law, but historically they have been a small part of the docket. To give an unscientific illustration, if you look at the indexes of the five recent volumes of the ICJ reports covering 1994 to 1997 sitting in my bookcase, you will see very few references to human rights. Para. Those you do see are concentrated in dissenting or separate opinions of a few judges. Thus, human rights issues have been an intermittent and not especially important part of the court's work. Para. In recent years, there have been a few more such cases helping to stimulate this symposium. The court's responses have varied when faced with competing legal values. Today's court does not necessarily give human rights claims special weight or authority. It takes such claims quite seriously, but I do not see it as taking a uniformly pro human rights approach. Para. In some cases, human rights values obviously have been given great weight in the two consular notifications cases by Paraguay and Germany against the United States. It clearly was of central importance to the court that the cases ultimately involved convicted persons facing capital punishment. I think this significantly shaped both the procedures and the final result. Although the court's task was made simpler by the fact that the United States admitted the core violation of the convention, I hope that Donald Donovan will address these cases in which he played an important role as counsel for Paraguay and Germany. I will not go into them beyond indicating the general thought that the court handled those cases as it did and reached some of the results it reached because they involved the administration of the death penalty. For the court, this aspect was much more compelling than the arguments regarding state practice and the construction of the treaty advanced by the United States. Stop.